Good evening, ladies and gentlemen. Good afternoon, good morning, depending from where you are dialing in for our session. Welcome to our video roundtable on the HCCH 2019 Judgments Convention. This is an event that is organized by two institutions, the Hague Conference on Private International Law, the HCCH, and my special welcome goes to its Secretary General, Dr. Christoph Bernasconi. Welcome to this session. We are very grateful to have you here tonight. The other institution is, of course, the University of Bonn. It's Institute for German and International Procedural Law. And I'm very grateful that my co-director, Professor Moritz Brinkmann, is with us tonight. Thank you very much for being with us tonight and for supporting our common project. We are receiving support for our work in this matter by the German Federal Ministry of Justice and Consumer Protection, and my special welcome goes to its representative, Dr. Jan Teubel. Thank you very much, not only for sponsoring, supporting our work, but also and primarily for being part of this panel. Thank you very much for that. It is my great pleasure and privilege to be moderating this event together with Dr. João Ribeiro Vidaui, First Secretary of the HCCH, to whom I will hand over in a few moments. This video roundtable is going to explore the prospects of the convention from a particular perspective. And this is the perspective of the relations between the EU and third states, neighboring states, trade partners in particular, but also other third states. And we may even look for a few moments to the relations of such third states amongst each other. We are very happy to have received a large number of registrations from all over the world and from all areas of interest: politics, policy, lawmaking, institutions, governments, dispute resolution practice, legal and economic scholarship. And we are very happy to have you all in our video session, and we are looking forward to having an intense exchange of thoughts with all of you and our highly distinguished panelists. Our event today is conceptualized as a self-standing session, but it's also preparing our so-called main conference on the HCCH 2019 Judgments Convention that will hopefully take place on the 13th and 14th of September 2021. Please save the date, mark it in your calendar, and it is planned to be taking place here in Bonn on site. Let's hope the best. Most of the highly distinguished speakers of that main conference are with us today. Thank you very much for that. And these, as well as many of you, will hopefully intervene at some stage. My special thanks go once more to the HCCH for co-hosting this roundtable and the main conference. And I'm now handing over to João. Thank you very much.
Thank you, Matthias, and good morning, good afternoon, good evening to everyone. I and the transnational litigation team at the Permanent Bureau with my colleague Ning Zhao, that is also here with us, will just echo Matthias with thanking all of you and the speakers, and also saying that we are truly grateful to the University of Bonn, of course. We will hear from our Secretary General in a moment, but I would like to convey our deepest appreciation for the support of the university and of Professor Weller and of his colleagues, especially because of the resilience that they have shown, allowing us to gather today for one more step to promote the Judgments Convention. And this event resisted full cancellation, as had to be the case for other two events, one in New York and another in Milan. And I must therefore recall that this event follows an inaugural promotional conference in Hong Kong, China in September 2019, co-organized with the Department of Justice of Hong Kong. And it also follows a special presentation in Uruguay in November 2019 for the occasion of the annual ASADIP meeting. This means that the promotional activity of the HCCH in relation to the convention has already taken place in the Americas, in Asia, and now in Europe, within a little more than a year after the adoption of the convention. And I believe that this is a testament to the momentum that the convention is building even amid a global pandemic. But let's start this roundtable. Before giving the screen back to Matthias, please note that our session will take 90 minutes with some tolerance, and that tolerance will quickly become intolerant once we reach 120 minutes. And we will hear from our panel over the coming hour or so, and only after that, we will open the floor for a Q&A session. Due to the overwhelming number of registrations, the moderators have agreed to manage the questions through the chat room. By now, many of you are well used to it, so if you have a question for any panelist, please write it down in the chat room, identifying yourself, including your affiliation, and indicating the addressee of your question. You will notice that there will be one principal moderator for each panelist, but the other moderator may step in during that slot, so please do not get surprised by that. We coordinate it. And finally, a necessary disclaimer. Indeed, this event is co-organized with the Permanent Bureau of the Hague Conference, and I am co-moderating, of course, also in my capacity of First Secretary overseeing the Judgments Convention. However, please do note that the content and the tone of whatever questions coming out of my mouth do not necessarily reflect the views of the Permanent Bureau or of the HCCH, simply because they were agreed upon among the organizers and the panelists. Time to play ball. Back to you, Matthias.
Thank you very much, Joao. The first round of questions should go to the HCCH, to its Secretary General. And if I may start that way, Christoph, I would like to raise maybe as a start, a somewhat obvious question, if I may, and that is the following. How can our convention, your convention, still be beneficial to the international legal society, given the existence of a number of other international, regional instruments in the field of cross-border dispute resolution, judicial cooperation? What are the benefits of the new convention?
Thank you very much, Matthias. And first of all, hello to everyone. Thank you for joining from various parts of the world. Pleased to be here and to be joined by wonderful colleagues and experts. If I may also from my part, Matthias, special thanks to you and your colleagues of the University of Bonn and all others who made this event possible. Thank you also for the excellent cooperation with my colleagues, Joao and Ning, who is sitting at the appropriate distance here from me in the conference room. Well, I can think of various ways in which the Judgments Convention can indeed be beneficial, but let's first recall the sheer importance of its adoption. It is, in my humble view, and some will of course say that I'm not very objective in that assessment, but still, in my humble view, its adoption is of historic dimension. Why? Well, because it's a game changer. And I've said that on the day of its adoption on the 2nd of July 2019, it is the first truly global instrument in its field. For the first time, the global community, well and widely represented, though I would have liked to have a bit more African states present, but still, for the first time, the world community agreed by consensus on an instrument to facilitate international circulation of judgments. And in that respect, it is absolutely a game changer. Now, the ball, of course, is in the court, if I may say so, of our members and other interested states to actually give effect to this possibility, which is now at their disposal. But the convention is a missing piece of the puzzle. The Judgments Convention, indeed, together with the Choice of Court Convention, offers one more effective option for dispute resolution at the global level, something that Lugano, Brussels, and all the other regional regimes simply cannot provide. These conventions, both Choice of Court and Judgments, are also what could be called enablers of international commercial courts. They enable the effectiveness of international commercial courts, which are a notable trend nowadays. Again, something that the New York Convention, for example, cannot provide. And there is, as a result of all of that, more access to justice. When deciding whether to go to court or go for arbitration, one of the elements that one takes into account is the subsequent enforcement of the decision or award. And until now, arbitration obviously had a significant head start because of the very successful New York Convention. Now, however, when it comes to judicial redress, one does not have just to give up one's rights. Now there is a possibility for judgments to actually circulate at the global level and to be enforced abroad. Both the Choice of Court and Judgments Conventions provide a legal redress possibility that in many cases would otherwise not be available for many individuals and companies. Which brings me to the next argument. The Judgments Convention is an affordable option. For many micro, small, and medium-sized businesses, MSMEs, litigation in front of a court is the only or the most accessible and affordable means to settle a cross-border dispute. Finally, I think the Judgments Convention and also the Choice of Court Convention support better trade and investment. Legal certainty and predictability has an economic impact. By reducing legal risks, companies will be able to reduce the price of doing business across borders, which results in a significant way from the incorporation of legal risks. So you diminish the legal risks by knowing what the rules of the game are and how likely you will be in a position to actually enforce your judgment abroad. So summing up, given these benefits, it is for members and interested states, including everyone here today, tonight, this morning, whatever it is, to actively consider and promote the convention so that states and the European Union, of course, will join rather sooner than later. Back to you, Matthias.
Thank you very much. Allow me to take up a few aspects of your answer. You described the new convention as a game changer. This reminds me of a statement by the Supreme Court President of Singapore, Sundaresh Menon, who said the same on the 2005 HCCH Convention on Choice of Court Agreements. It is another obvious question of mine. Would you see now a package of judicial cooperation instruments on the table provided by the HCCH that should ideally be ratified, acceded, agreed upon by states thinking about judicial cooperation, about establishing cooperation with other states? Should this package be handled as a package? Should it be recommended by us as a package?
Thank you, Matthias. And first of all, your reference to Chief Justice Menon reminds me quite visually of a most impressive and interesting encounter I had with him. I had the pleasure of meeting him a few years ago at the Supreme Court in Singapore, together with our then representative of our regional office in Hong Kong, Anselmo Reyes. And I started to talk about the Choice of Court Convention to Chief Justice Menon, and after 3 minutes, he said, "Enough. I understand exactly what this convention is all about and what benefits it will bring to us in Singapore. Where do I sign? Where do I ratify?" And the rest is history. And of course, Singapore wanted to establish itself as a judicial hub in the region, and the Choice of Court Convention was a very, very important element of that policy. And now the convention obviously is in force in Singapore. But back to your question about the package. Yes, I truly and absolutely believe that choice of court and judgments, but also service, evidence, possibly access to justice, do form an effective package. They are complementary, and as such, I think would benefit indeed from being adopted as a package, avoiding any gaps. The advantages of such a comprehensive approach are obvious. I think as a state, as government authorities, one would save time and costs with the legislative process. If you have to go through the whole process only once, that's certainly a big advantage as opposed to embarking on that same process again and again. I think it would also save adoption and switching costs with, for example, legal and judicial training and education. And one should not forget that all these conventions come with the benefits and the very important advantages of effective post-convention services that the HCCH and in particular its permanent bureau offer, including special commissions on the practical operation of these conventions, where experts come together from all the contracting parties and interested states to discuss the practical operation of the convention. Which brings me, if I may, Matthias, to another important point, which is uniform interpretation, also again across various instruments. For example, when it comes to civil or commercial matters, but one could think of other examples. But the uniform interpretation of the convention is paramount for the effective implementation and operation of the convention. It is an international obligation under the convention itself. And with time, one can imagine that this will require accessible repositories and databases, where you can search for doctrine and jurisprudence, case law in multiple languages that would certainly effectively support the operation of these conventions. But that is more for the future. But one of the reasons why I do want to talk about uniform interpretation is, of course, one of the most important tools to guarantee or facilitate rather this uniform interpretation is the explanatory report. And you may know that the explanatory report, the wonderful report prepared by Professors Francisco Garcia-Martin and Geneviève Sommier. I have not been able to check now quickly if they are on the call, but I had seen that they had registered. But first of all, if you are on the call, thank you very much again to both of you for producing such a wonderful report. And here it is. This is hot from the press. I don't know if you can see it, probably like this, something, yeah. It's, of course, the report has been approved by our members and it was last month. And it is now also available as this, a nice, glossy, good-looking publication in Burgundy red, I'm being told. And I can tell you that the report tastes really like a Grand Cru from the region. Of course, the explanatory report is, as good as it is non-binding in nature. It's a very authoritative source for the uniform interpretation of the convention, and it reflects negotiations of the history, also by referring and using examples. But this package of relevant HCCH conventions in cross-border litigation, this package forms a system of a global HCCH framework to effectively support cross-border trade and commerce and foreign direct investment with an effective dispute resolution framework, including cross-border cooperation when it comes to the more procedural aspects of the issue.
Thank you.
It is the HCCH system, the HCCH conventions that provide the sole legal infrastructure for predictable transnational litigation. And one can think, of course, of choice of court, recognition and enforcement, service, taking of evidence, the principles, I should mention also our soft law instrument on the law applicable to international commercial contracts, again, access to justice. And if we are asked for a kind of a long-term vision in this regard, we can think of a global network also of judiciaries cooperating and coordinating, speaking the same consensually agreed civil procedural language. This is really where we should go for, what we should aim for. And the possible future instrument addressing matters relating to jurisdiction, direct grounds of jurisdiction, including parallel proceedings, will of course, or would of course, only further this approach and support this effective approach and make the case for a global HCCH system. So yes, a package it is, a system it provides, and it comes with a lot of benefits. Back to you.
This is an inspiring vision, Christoph. We are, we would love to see it happen, so to speak, which brings us to the question of ratifications. And this is maybe the moment where I hand over to João to turn to our next panelist who is involved in this question.
Well, we missed a little bit the surprise effect now, but I am charged with the question that may be considered simultaneously the most important question of this session, and also, I hope, a rhetorical one. And so, Andreas, the question is very simple. Will the EU adhere to the convention?
Yeah, good evening, Joao. Good evening, Matthias. A great evening, or whatever time of the day it is from where you're joining. From my side, it's a pleasure to be with you and to be a part of this event. It would have been an even bigger pleasure to do this in person in Bonn, which just happens to be my hometown. But we have to deal with the circumstances. Yeah, the question is a short question, maybe the shortest question that will be asked this evening. It's also a yes or no question, which, you know, those are the most difficult ones. And you also know that out of lawyers, it's very difficult to get replies to these things. And the most likely reply you will ever get is that depends. Jokes aside, I think it is slightly above my pay grade to make a particular firm announcement in that respect. You need a number of policy decisions along the way. The Commission needs to decide to table this as a proposal. The Council needs to take a decision on this. The European Parliament needs to give its assent. We're in the world of politics, so there is nothing that couldn't be subject to unpredictable development. So unfortunately, I can't give you the very simple yes or no reply, but I think I can provide some background information that will inform speculation, sort of, you know, well-educated speculation on what the EU will do. And the first thing that I want to mention in that respect is that this has always been a flagship project for the EU. From the very inception of this project, it was a flagship project for us. The EU was not discouraged by the setbacks that we have seen in the process. The EU has ratified the Choice of Court Convention, full well aware of the fact that this is a packaged approach. It has taken a very proactive position in the negotiations of the Judgments Convention, and it is also enthusiastic about the work that is now starting on the third element of the package, the jurisdiction project. So we've always had a very favorable predisposition to this, and maybe it's an advantage of not representing a single nation state, but representing a regional economic integration organization, to use the parlance of the convention itself, because of course we have to coordinate with member states at every step of the way on every individual issue that was up for discussion in the adoption process. And I think in that process you get a certain feeling for the temperature towards this instrument. And what I can say, and I hope Jan will not contradict me later on when he speaks on behalf of of Germany, that there was always a very positive vibe about this convention. I can also share with you that, you know, when we discussed the outcome of the conference last year and the final version of the convention, of course, we also had to coordinate and decide on whether this is a good text for us. We were in a position to give that positive signal and to agree to the adoption, which is already quite a step for such a coordination process. And we know from the exchanges with our member states that although we would have been a little more ambitious, we would have liked some things to be different from the way they are in the final version of the convention. We are broadly speaking pretty happy with the outcome. Now, that doesn't give you any guarantee about what's going to happen in the future, but let me just put it this way. I would be very surprised if now we face a complete turnaround in the views that at least member states will take on this project. What I can tell you for sure is that we're in the midst of the process as the Commission. We're in the middle of an impact assessment, which is a necessary prerequisite in order to make a proposal for ratification or for accession where we discuss and assess the impacts of the different policy options, of which there are some. Of course, there's always the binary ratify, do not ratify, but of course we have a number of declarations that can be made that will be analyzed, and the impacts of that will be analyzed in the impact assessment. So we think that we'll have the impact assessment at some point in spring next year, and the intention is to prepare a proposal for the first step of this process for a Commission decision on, whether or not to propose the ratification in the first half of next year, and we're pretty optimistic that we can, even in COVID circumstances, which have slowed down our work a bit, that we're well on track, and we should more or less be able to comply with that timeline. So the final outcome on what the Commission will do, you will see probably next summer, but I hope I have given some useful information sort of underpinning what may or may not be your legitimate expectations in that respect.
Absolutely, and I think that's quite promising. And somehow you hinted that the convention has several mechanisms of flexibility, let's call it like that. And one of those is, of course, Article 29. And I know that today in another event, there was some discussion about it. And so the convention allows this selectivity vis-a-vis other contracting parties. Some call it a system of determining mutual trust. You can call it also a layered trust system. There have been some observers and academics, including some in this call, that have been asking if there will be some sort of an assessment of the quality of justice systems similar to those that the Justice Scoreboard does, even though the differences within the EU are not an obstacle for the narrative of mutual trust to work within the EU. So the question is, how is the EU and the Commission going to monitor this issue and assess how to establish treaty relations with newcomers to the conventions? And again, if you take too long, there will be probably other parties to the convention already if it's in force. So how will that assessment be done from your part?
Yeah, thanks, Joao. I think maybe before I come to the more procedural point of how we deal with implementing Article 29 from the EU side, maybe it's first important to make a little note on sort of our general position vis-a-vis this article. And I think it's useful maybe for the participants who, at least those who haven't been in the negotiations themselves, to know that the EU and its member states, have not been the most vocal party in the negotiations asking for such a rule. I mean, I think there was a broad spectrum of voices on this. Some who wanted basically a general bilateralization, if much farther-reaching system to deal with issues basically of rule of law problems in other potential or existing contracting parties to the convention. Some others were fundamentally opposed to any such system, and we were not huge fans, if I may call it that, of a very rigid bilateralization system, as it was referred to, also against the background of the experience with the 1971 convention, which didn't turn out to be such a great success, which is why we had to have a fresh start at the whole project. And a very cumbersome and rigid system of basically entering into bilateral agreements with every single other contracting party, to us, and not only to us, I think this is a very widely shared view, was one of the secrets to the lack of success of the 1971 convention, and we didn't want to run into that same dead-end street again. So I think it's fair to say that, from our perspective, what has come out of the negotiations is a pretty reasonable compromise that provides what I would refer to as sort of an entry control to the system. I think it's also fair to say that, you know, as this was discussed in the negotiations, I think the spirit of this provision as we see it is not for this article to be something that is routinely used in actual practice, but we understand it as something that, you know, provides an emergency brake in what we hope will be exceptional circumstances where really it is unacceptable to enter into treaty relationships with another contracting party. And broadly speaking, we would intend to apply it in that spirit. We think it would be an unrealistic expectation to think that you will only have relationships under the convention with other parties that live up precisely to what you understand as, you know, the ideal, or at least as good as you are. And of course, everyone thinks, you know, your self-perception is always a very positive one. I think in these situations, a judgment will have to be made as to whether the situation in an aspiring contracting party is such, you know, that it's reasonable to allow the recognition and enforcement of judgments from that other contracting party in view of the safeguards that are already enshrined in the convention, including, of course, the ordre public refusal ground that already provides an emergency brake if you think something is seriously wrong. So that was my general point. Now, on the procedural part that you have inquired about, I think this is not an exceptional situation, neither as to the existence of such an objection clause, nor to the EU having to have a procedure on this. We have this in a number of other conventions already, like the 1996 Child Protection Convention, the 2007 Maintenance Convention, to which the EU is a party itself. So this has happened quite frequently already. And what I can tell you is how this has played out so far. I think member states have taken a very constructive view in terms of, you know, considering the situation in other contracting parties. Of course, this is a different ball game. Family law is a different ball game from civil and commercial relations. But when you talk about child protection, I think the rule of law situation in another contracting party is already also quite a sensitive issue to take into consideration. And so far, there is no record of saying no to anyone acceding to those conventions. Now, as far as the procedure is concerned, what we're doing at the moment is that whenever we have to consider a new contracting party, the Commission comes forward with a document assessing the situation in that country. And, you know, we rely on our own sources. We have EU delegations around the world. We get their views, we get their input. Of course, we also use the network of member states, which have, you know, particular insights and privileged knowledge in some countries rather than in others. We may also rely on other sources of information, the World Bank, NGOs, the World Justice System. And we put something on the table from the Commission side, which is then for discussion among member states. And then we have a discussion process in the responsible Council working group where we form an opinion on whether there are serious grounds to consider an objection or there are not. And this is a mechanism that has worked well for the existing Hague Conventions with an objection mechanism. And we hope and believe that it will have the same, it will play the same constructive role also in the future. And inshallah, if we ratify, also for the operation of Article 29.
Well, this links very well to the next question, and keeping the roundtable on policy tracks, and I know this is also a topic dear to you and to your Director General. Judicial cooperation, of course, in civil matters is one of the most dynamic policies within the EU, and it supports, of course, the internal market. And we found in preparation, of course, of the roundtable, some policy papers, including a note from the Austrian presidency in 2006 that recommended extending the judicial cooperation schemes to third states. It's still unclear how this is really being implemented. I know that your Director General has some actual experience in trying to implement such policy, but is it fair to say that while this is a very important topic internally, there is a little bit of a blind spot here externally, and how this will be more serious in relation when we take into consideration that the Commission will have to do the assessments that you just referred to when considering establishing treaty relations?
Thank you very much, João. You asked me if it's a fair judgment to conclude that there is a bit of a blind spot in the EU for these international issues. And that exceptionally is a yes or no question to which I can give a clear reply. And I think in principle, the answer is no. I think that's not a fair description of what we're doing. I don't think we have a blind spot in that respect. And frankly, I have taken the executive decision to not consult my colleagues who are dealing with international issues on this question, because I think they would have reacted with a certain degree of bewilderment to that question. I think it would take me much longer than I have to give you an overview of how much work we're doing in relation to international judicial cooperation. And João, just looking at you as the moderator responsible for that question, I'm wondering if you would seriously come to the conclusion that you don't see enough of us in The Hague in relation to all the projects that are ongoing there, or that you think we're too silent, too humble, and too sort of withdrawn, and we don't really care about this. I think in reality, it's rather the opposite. And I think also, to be fair, the document, I've taken a look at the excerpt that you've taken from the Council document, which, to be fair, is from 2006. That is from a moment where it had the Lugano opinion by the European Court of Justice giving the EU exclusive external competence on the matters related to the Judgments Convention was just out, and everyone was trying to come to grips with that new situation. And even in that, I think it's important that even in that document, what is said is that yes, we will have to see, how we deal, with third countries, which might be an allusion, although it's not explicit, that this is about bilateral relations with third countries. But very importantly, that text concludes by saying, in particular, the work undertaken within the Hague Conference on Private International Law has provided for useful exchanges with third countries. So already at that time, there was a very strong statement that the multilateral work is the key battleground, or playground, whatever you want to call it, for taking this.
If I may step in at that moment, if it's allowed, I very much share the question of my co-moderator about whether there is a blind spot somewhere in the judicial cooperation. And let me maybe add a little bit to that. We accept what you said, and that there is a lot of activity, and hopefully there is the great step forward soon in the future. But if we look at the trade relations that are established by the EU with third states, we must observe that the offers by the HCCH are not always taken up. in the trade negotiations or alongside these trade negotiations. There are a number of third states in trade FTAs now, free trade agreements, and some of them are contracting parties to some of the conventions of the HCCH. Others are not, and there seems to be at least no package idea so far. That's at least something that could be observed and that could be maybe described as some sort of a blind spot, which is hopefully, of course, being overcome by all the activities that you described.
If you allow me to sort of also take that into consideration in the reply, obviously we have our trade colleague also as a participant who may comment on this later on when he's being asked questions. But I think, and that's the point that I wanted to come to next, is that moving on 15 years after the 2006 document that you have quoted from, we just had council conclusions under the Finnish presidency in December 2019 on judicial cooperation, and there was a specific point on international judicial cooperation where the council concluded that there is a clear priority on a multilateral approach to international judicial cooperation. And there is a sentence that explicitly says, well, only in cases where the multilateral approach is not effective or cannot be put into practice, the Commission is invited to provide alternative or to consider alternative options. So I think what describes the EU position very fairly on international judicial cooperation is a clear priority on a multilateral approach. And it is in that context, that we have prioritized this project of the Judgments Convention over a long period, because we thought that the adoption of that convention and a broad ratification of that convention, would be the best option. Now, you raised the question basically not whether it's important to us, but via which policy tools we try to ensure, basically a broader ratification. If I understand your question correctly, you say, well, in trade negotiations, you could make it part of the package, that the other side who is interested in a trade agreement should also at least become party to such and such Hague conventions, or if they don't exist, which the Judgments Convention, which clearly in the civil and commercial area, it should be the key instrument. It's only available now. So until we had the Judgments Convention, that wasn't really an option. So in trade agreements, we would possibly have to negotiate a separate system of rules of recognition and enforcement of judgments in those trade agreements. And I think that's a pretty tall order to also have a full-fledged negotiation on judicial cooperation within the context of what already is quite a complex issue. So I think we will certainly promote, specifically if we ratify, now the Judgments Convention with the means that we have. Whether that's a yes or no, a make or break question for a trade agreement is another political question to reply. But I think the broad brush judgment that we haven't thought about this, or we haven't considered this in our international relations, I would not subscribe.
Thank you, Andreas. And actually, we are just setting the stage for Colin to shine later on. Thank you very much. And Matthias, it's back to you, I think, now.
Thank you very much, Joao. Thank you very much, Andreas. Let's turn to one of the member states for a moment, to Germany, and to Jan. Looking at Germany as a leading export economy, does the German Ministry of Justice support ratification of the HCCH 2019 Judgments Convention by the EU? I would guess so, but maybe there are additional reasons that tell us that is the right direction to think.
Well, dear Matthias, thank you very much for this question. And first of all, I would like to thank the University of Bonn and the HCCH for organizing this event. And now turning to your question, as Andreas has already said, this is a political question, so I have to make the usual caveats. And we, as obviously it depends on what proposal the EU will make or when, and whether there are what declarations or whatever will be contained in that. So first of all, I have to say the German government does not have a firm position. That is the point I have to make. But anyhow, I can pretty much echo what Andreas said, which is true for Germany as well. For Germany, as a leading export economy, it is very important to strengthen the open and rule-based international trade systems. And we can see in the current pandemic situation how fragile the international trade relations can be. And for the German Ministry of Justice, it's vital to complement such trade relations by judicial cooperation. And as such, we are very, very much in favor of multilateral agreements that can enhance recognition and enforcement of judgments in civil and commercial matters, because this is a major step to complement international trade agreements. So having said that, we look favorably, obviously, of the 2019 convention, and Germany, and that goes beyond the Judgments Convention. Germany is firmly committed to a multilateral approach and to the work the Hague Conference has been doing for the more than now 127 years, I guess. And we always promote the accession or we generally promote accession to the Hague Conventions. So what I can say from a German perspective, it is a very good convention. And when we see a proposal by the Commission, we will make up our mind, or we will come to a firm position of the German government. But for the time being, I can fully, with wholeheartedly, can say that the German Federal Ministry of Justice is very much supportive and would like to see a proposal by the Commission as soon as possible on ratification or accession.
Thank you. Are you as relaxed as Andreas is on the issue of Article 29, which is the question of the quality of the justice systems of potential contracting states from far and remote places of the world, or maybe also close places to the EU? Is there any intention from the side of the German government to contribute to the process of assessing or maybe reviewing the quality of justice systems when it comes to the question how and whether and how to exercise the options that are granted to the contracting states under Article 29?
Well, obviously, first of all, what I want to say first of all is Article 29 is, I think, as Andreas already said, and that's very true, a last resort option, I think. So it's not something that we should not make such a notification regularly or lightheartedly. So it's something which is obviously, I think, has a very, very grave impact. And as Andreas has already said, this is not something new. We have seen it in other Hague conventions. And of course, Germany is assessing whether the legal systems in other states should and would allow us to take up contractual relations with those states in this. So again, Andreas mentioned the 1996 Child Protection Convention, and again, it's a similar system, and we are obviously collaborating with our colleagues from the Foreign Ministry on whether there's a systemic problem in certain states. And yes, this is obviously a very important point also for us. And we will gladly try to work constructively with the Commission on, if that issue arises, on how to assess whether whether this notification system should be invoked. But again, I would like to stress that I think it's a last resort option generally.
Thank you very much. Last question from my side. Germany is currently running the presidency of the Council of the European Union. Is there anything in its agenda that relates to judicial cooperation, perhaps? I mean, we've just heard from Andreas about the timeline that might lead, hopefully, will lead to ratification. So it seems to be a thing that is beyond the time of the German presidency. You are nodding already. So that's something we must postpone, and maybe the question forward to the next presidency. But nevertheless, is there anything of relevance to judicial cooperation on the agenda for the German presidency?
Well, obviously you are right that as regards the Judgments Convention, we don't have anything on the agenda. But again, that's not because we don't like the Judgments Convention, but rather because of the situation as it is. It's up to the Commission to make a proposal to ratify. And Andreas has already told us about the situation as it is. And back in February, when we planned our presidency, we had talks with Andreas, and he was telling us maybe end of the year there could be possibly a proposal if everything works really fast and smoothly. And then obviously the COVID pandemic came up, and so we don't have any thing about the Judgments Convention. But also speaking of the Hague Conference, I think the German government is hosting a conference on, I think it's now 50 years of the Taking of Evidence Convention of 1970, and there will be an event, I guess, in December. So yes, we are also looking at other things of judicial cooperation and trying to promote those as well.
Excellent. Thank you very much. And I'm handing over to Joao.
Thank you. And yes, indeed, on the 2nd of December, there will be what we call an abridged event. The edition 2020 will be organized with the German presidency for the golden anniversary of the Taking of Evidence Convention. Just a quick note in relation to the discussion we had on Article 29, and also in relation to other provisions of the Convention. One should never forget that any discussion about the Convention cannot ignore the status quo, and the discussion needs to confront the status quo in relation to the Convention, not discuss provisions of the Convention as a bubble. But probably I'm going a little bit off my moderator role. And now Veronica. Veronica is managing a very exciting project in Southeastern Europe on behalf of GIZ, and recently that project has embraced the promotion of the Judgments Convention in close collaboration with the Permanent Bureau. I know you want to share with us a first presentation, views on how that project is developing. You have the screen.
Okay, can you hear? Okay, thank you, Joa. I would like to greet all of the participants and thank you for giving us the space to present what we are doing in the Southeast Europe, commissioned by the German Federal Ministry for Economic Development and Cooperation. Historically, we are doing support in the Southeast Europe, which is related to this topic, cross-border enforcement, international private law and civil law since 2010. And it's very interesting and exciting since the countries are in the EU accession process, meaning that they are negotiating or at the moment being still in a candidate status. So it means that getting closer to the European Union. And what is relevant for us is that maybe some of you are already informed. In 2015, there was an attempt in this region to sign the so-called Sarajevo Convention, which is something that is related now to the Hague Judgments Convention. So the countries for 3 years were negotiating actually the Convention on Jurisdiction and the Mutual Recognition and Enforcement of Judgments in Civil and Commercial Matters only for that region, so the so-called Western Balkan countries. Unfortunately, this convention was not signed at that time, as it was one of the attempts afterwards to come to a common regional agreement in this matter. But now we hope that this international convention will facilitate their acceding to this. What I would like to share as the Hague Conference on Private International Law is one of our key partners, and we are doing together, as this is now globally priority on the agenda, the promotion of the convention and convincing the states about the benefits of it and why they should accede and ratify the convention. First of all is about convincing the policymakers and those who are responsible for this, and on the other side, the judiciary and enforcement professionals who will deal actually with the enforcement of foreign judgments. So our project is supporting the governments of these countries in this respect. And I would like to mention that this is not new for Southeast Europe, as they have historical tradition and relations with the Hague Conference. 5 out of 6 countries are already members, and they have already joined and acceded as a contracting party to many other Hague conventions. So this is not a novelty, and we hope that our support will be beneficial for moving the way forward to convincing the states in the next coming years to ratify the convention. So, Joa, this is just as an introductory.
Thank you, Veronica. And actually, this kind of links a little bit with Article 29. I don't want to go back to it, but you kind of hinted at one of the possibilities that the article and the system of establishing treaty relations offers, including this possibility of a group of states establishing relations among themselves as a closed group, before establishing other treaty relations with other partners. And that's why some call it more as a plurilateral convention than a multilateral convention. But in that sense, and during your discussions in the field, you are reporting to us from the field, dealing with potential future contracting parties. Is this a topic of concern? To what extent other parties will assess the viability of establishing treaty relations with the countries from the region?
Yes, thank you, Joa. As I mentioned, these countries are already in the process of regional cooperation in many areas. So in this respect, judicial cooperation in civil, but also commercial matters is something that they are already doing in specific aspects. This will just come as a update of their relations. But what is very important at the moment is we have to take into consideration that none of these countries so far have any reservations towards the Hague Convention. So there is a positive perception about the convention and what it might bring as an advantage and benefits to the region. But on the other hand, we have to take into consideration that no matter that they are sharing a common history and common legal system from the previous times, at the moment, we have definitely difference in the legal systems in the region. And that might be, not to say obstacle, but a challenge for the ratification and for the enforcement. Having in mind, for an example, in Bosnia and Herzegovina, we still have the court enforcement. So there is a huge backlog of cases in the courts. And in the other countries, we already have private or public enforcement of judgments. So there is a difference, and that should be somehow be taken into consideration when they will opt in to the convention, and they would make the relations with other countries to enforce their foreign judgments. In this respect, I would like to point out that the Hague Judgments Convention definitely will build these bridges between the countries and will try to overcome the complexity of different legal systems, especially in this region of the Western Balkans. It will streamline and facilitate cross-border cooperation, but on the other hand, what is the advantage and what should bring added value is that will make the procedures less complex, which is at the moment less lengthy. So we are facing with procedures of years, going years for one case to come to the end and to start with enforcement of the judgment. And what I would emphasize significantly will reduce the financial costs. So this is something which is really a burden, not only for the companies, also for the citizens as end users of the judgment. So this is something that they are seeing as an added value at the end.
Thank you very much. And that highlights how much work is being done in the region, and potentially we will have some of the first contracting parties coming from that region, joining others that I'm taking the chance to share. Uruguay is proceeding with ratification preparations. Brazil has concluded also its public consultation procedure, as did the EU this month. And Russia just tabled a proposal to cabinet to sign the convention. So it's looking good to enter into force in 2022. Let's hope for that. Back to you, Matthias.
Thank you, Joao, and thank you, Veronica. Let's turn to the practitioner's perspective. Alexandra, you are partner with White & Case in Frankfurt-based. Your field is international commercial dispute resolution in all aspects, and you have a particular emphasis on international commercial arbitration. Arbitration is, of course, of utmost importance and value for cross-border trade relations, of course. However, if there is no alternative dispute resolution, as I would like to put it, and that is the most widely used narrative for legitimizing arbitration. Would you perhaps agree that judicial cooperation of state courts is indispensable in this picture for building up something that could be called an integrated approach for commercial dispute resolution including litigation and arbitration, perhaps even mediation, if we think about the recent UN 2018 Singapore mediation convention. What is your experience from practice?
Good evening and hello also from my side, and also many thanks to HCCH and the University of Bonn. Matthias, as a dispute resolution practitioner, I cannot help but noting that your question is to a certain degree a leading question. However, I do not mind, exceptionally, because I agree to the underlying proposition. Although I have to say, I belong to those who would not say that arbitration is alternative dispute resolution. You know that there are certain theories about that, contrary to mediation or conciliation. So I would see arbitration more in the same camp, so to speak, as litigation. The Judgment Convention aims at increasing the attractiveness of international litigation. That is to be welcomed, and therefore I agree to your proposition, and may work in the favor not just of international litigation, but also international arbitration. Competition in the field of dispute resolution in general, I would say, is beneficial for its users, meaning the commercial parties. There are, as we all know, many areas of law where parties, especially to cross-border contracts, traditionally and generally agree on arbitration. Christoph mentioned a head start in his talk that arbitration may have in certain areas, especially in the context of M&A transaction, but also notably right now, from my perspective, for example, reinsurance contracts, the latter being an area where we see many disputes coming up because of the COVID-19 situation. This has the consequence that there are many areas of substantive law without any reliable published case law, because as we all know, not all arbitral awards, especially in the area of commercial arbitration. This is problematic in terms of legal certainty and also predictability. It is also problematic from my perspective because judges are not trained in such cases involving complex transactions and may not be prepared when they arrive on their desk. Because of that, it's important indeed that international litigation is fortified. And yes, I also agree to Christoph in this respect. This is a missing piece where the convention is especially important. This is also in the interest of arbitration because state courts decide about motions to set aside, and this will enable them to do that possibly even better. Moreover, I have experienced certain arbitration, which frankly speaking, I would have preferred to be moved to a regular courtroom. These were typical contractual disputes dealing with interpretation issues and not so sensitive matters, perhaps. Where at least a German judge, and I do, as most of the practitioners in Germany also do commercial litigation before German courts, would have likely not heard witnesses. The arbitrators heard witnesses for an entire day or even longer in both of the cases I am particularly thinking about right now. And of course, there were witness statements. We all know that this is the common standard in arbitration. At the end, however, the arbitrators concluded that their initial evaluation of the case, based on the documents they had analyzed, was still accurate. This could have been achieved much faster and also less expensive in a litigation. It is essential, from my perspective, for the success of international litigation that its users perceive the travel of judicial decisions across borders as seamless as possible. Why is that so? Their business has become more integrated, and so must the means of dispute resolution. The Judicial Convention is an enormous step in the right direction in this regard, although I would not go as far right now. It remains to be seen to call it a game changer. However, to compete with arbitration, much more must be changed about the litigation system in many jurisdictions. Of course, more resources, professional structures, those kind of things are necessary, but also stricter case management in some situations, and also creativeness on the part of judges, sometimes at least. That does exist already. However, a good example for such creativity would, for example, be the framework, the Higher Regional Court of Düsseldorf. Excuse for mentioning this particular court, but Düsseldorf is my hometown, which developed for confidentiality in standard essential patent infringement proceedings a specific system of confidentiality, a two-step system. And of course, as we all know, confidentiality is one reason why arbitration sometimes has a head start as towards litigation. And of course, Matthias, I also agree that mediation comes into play here and must come into play. The Singapore Mediation Convention is another major step forward. The benefit of the convention is not only that it provides confidentiality, which is often important, and the machinery necessary to enforce settlement agreements in international mediation, it also reassures potential mediation participants that any agreements they reach will be enforceable. Back to you, Matthias.
Thank you very much for your comprehensive analysis of the needs and the situation in which we are from a practitioner's perspective in commercial dispute resolution. Christoph mentioned the commercial courts, the spreading of the international commercial courts all over the world. Germany is part of it, China is part of it, other countries are part of it. What is your view on this development? Is that adding to what you were calling for as needs from practice, or is it something that you would evaluate maybe as a more marginal development? What is your view in that respect?
This is another area where we all benefit from competition, from my perspective, to build up, as you called it, Matthias, an integrated approach for commercial dispute resolution. However, if that competition is also between cities and regions, as it is the case with regard to the development of commercial courts in Germany, which is unfortunately not untypical for Germany, this may be the opposite of integration. And I agree to Christoph as well, again, that this is a notable trend right now. There's also fierce competition among commercial courts, reminding me of the competition between arbitral institutions that has existed for a long time. In Europe, this development was triggered by Brexit, as many countries perceived a chance to take away certain disputes from London. Whether that will work will remain to be seen. I, however, believe that commercial courts will gain further momentum because of the COVID situation. In each case, commercial courts can offer many of the advantages users appreciate in arbitration, especially flexibility and specific experience in certain areas of law, and also sector experience, which is particularly important. A perfect mix together with the Judgment Convention for sure. A project I perceive right now, and I have to admit that, as particularly promising is the Netherlands Commercial Court. Interestingly, several clients have proactively asked me about this particular court, which has, I have to admit that as well, so far not been the case with regard to the Judgment Convention. So this is certainly something where we need to bring the message to the clients, and so far I have not been approached in this regard. This shows that this court is particularly effective when it comes to marketing. It has also heard some very interesting cases in recent times. For example, one concerning an agreed breakup fee due to the COVID-19 outbreak. One interesting feature of the court is also the possibility to bring class action, which is not the case for many other commercial courts, but this could be the subject of another webinar, of course. And of course, just like in arbitration, and as already mentioned, Singapore is a great driver of innovation in this regard, having introduced its commercial court already in 2015. However, a court, from my perspective, as I see it so far, very much influenced by common law judges, and therefore potentially less attractive for continental European clients. But overall, definitely a very important development, and the Judgment Convention definitely will further add to that.
Thank you very much. I would love to ask
if I might step in, as we warned everyone about it, so let me take advantage of it. But indeed, the Singapore court, it's really important to mention it and to recall that it's, I believe, the only one that has an international panel of judges from a diverse setting, including French judges, Chinese judges, and so it offers really a judicial setting inspired from what would be the traditional arbitral tribunal setting with high level of specialization. And so in that sense, it is mirroring a little bit the advantages that arbitration can offer. And I wanted to ask you if you don't see this also from an historical perspective, as a progressive natural trend towards litigation, in the sense that the New York Convention was adopted in 1958. It took 20 to 30 years to be fairly relevant beyond the protection of certain investments in certain parts of the world before it became really important on commercial disputes. So there is an historical context, economic, social, and judicial development argument to explain the evolution of arbitration and the importance of the New York Convention. Could we use the same argument to say that nowadays we see a similar evolution on judiciaries from all over the world, the quality of the judges, the quality of training, the international nature of their studies, of their interactions with foreign judiciaries? For those that are more familiar, 5 years ago, there was virtually almost no judicial training in China, and now there is a judicial training institution that is probably bigger than the entire area of the EU institutions in Brussels. So can we say that we can see a positive evolution on the side of the judiciary that naturally will result in more trust in the way judges can solve and address international disputes?
I would definitely agree to that, of course. I also look to Germany in this regard. I mean, I've criticized the regional approach that is sometimes applied here. But on the other hand, several higher regional courts in Germany have introduced chambers where the parties can have the proceedings in English. The first commercial court will actually be started on the 1st of November in Stuttgart, and it's now a natural and a very important condition for judges is that they are fluent in English, and that was not the case earlier. Also, I mean, I perceive many of my colleagues all over the world at White & Case very often do trainings with judges in many countries in Africa and elsewhere, and that I also perceive as a new development. I agree also, Joao, to your description of the Singapore court, that it really is comparable to arbitration because it has very experienced dispute resolution practitioners among its judges. I still see a certain higher influence of common law judges there, but of course there's also a member from Austria as well. And also the fact that there is a commercial court in China, as you mentioned, China, also adds to this development. Of course, this one is still very much dependent on the People's Supreme Court and also partially tied to the local judiciary, as for example, Article 10 of its procedural rules shows, which provides that the China International Commercial Court shall accept the case if Supreme People's Court so approves. Nevertheless, I think it can be a valuable, interesting middle ground for certain disputes with Chinese counterparties, and a very interesting development to be followed as well in the near future.
Thank you very much. The alternative is coming back to the scene, the alternative of commercial litigation in state courts, as I would summarize it, if you allow it, Alexandra. And I am very glad that you mentioned Brexit. I think for the first time in this session, if I'm not misled, we may come back to that later in the discussion, but now I would like to hand over for the last round to Joao. Thank you very much.
Thank you, Matthias. And I'm tasked with the first question to Colin, probably the toughest question of the night. The last time we talked, the ISDS reform was starting at Antitrust, and it's good to see you at a panel for transnational commercial litigation. And to my knowledge, there is no FTA of the EU, any agreement with any of its external trade partners that includes any chapter on judicial cooperation or commercial dispute resolution. And this links a little bit with the discussion with Andreas. And we know, of course, about the approach on investment courts and the concern with the protection of investors and how that is problematic within the European Parliament. It's one of the few topics where we can see from the far right to the far left some consensus. But trade agreements are meant to increase cross-border trade and business-to-business trade, not only investment. So if they are successful, it's fair to say that the number of related commercial disputes under those agreements will rise accordingly, potentially, or at least the assessment on the related risks by the EU businesses. So what about business-to-business disputes? Why during the negotiations? This doesn't seem to be part of the negotiations. And how are European businesses trading under these agreements? How can they be assured of a reliable and predictable dispute resolution system? The question in practical terms, would it make sense to include in this trade agreement some sort of a reference to ratification of the choice of courts and the judgments convention, as actually other regional trade agreements do in relation to other multilateral agreements from UNCITRAL on e-commerce, for instance? So basically, Colin, the ongoing negotiations, will a chapter on judicial cooperation be included?
Okay, well, thank you very much, and it's nice to see you again, João, after these years. And thank you to the University of Bonn and to HCCH for having invited me to take part. I feel a little bit like the stranger here, that this is a little bit a world that I'm much less familiar with. But it's very interesting for me to take part in this discussion and to listen to what you have to say. So I think one needs to place this question a bit in context. As Andreas was saying when the similar type of question was posed to him earlier on, the EU has developed a particular approach on these matters and is preferred to take a multilateral approach, as he was explaining. And when the EU contemplates a free trade agreement, negotiating a free trade agreement, the very kind of preliminary steps are scoping out, so working out what are the types of issues that we want to tackle. And we do that internally within the Commission, obviously in conjunction with other departments, other Directorate Generals, including DG Just and Andreas's unit, with whom we have a number of files where we have some overlaps. And the member states will do a similar thing. The trade part of member states administrations will also be speaking to the other departments when looking at what should define the union's what's commonly known as mandates or authorization and negotiating directives. And I think a big part of the explanation of why we haven't seen references to these conventions in trade agreements is precisely because of the direction of travel that Andreas was talking about earlier on, and that we want to follow that direction and not bring these matters into bilateral agreements. I think that it's useful to keep in mind also that the main mechanism for international trade, of course, is the World Trade Organization, the WTO. So most of our energy goes there and into managing that and handling disputes there. And the main focus when we negotiate a free trade agreement is there a market with high barriers, which is difficult to get into, and where if we negotiate a free trade agreement, we can hope to remove a significant amount of those barriers and hence free trade. So it tends to be the case that we're negotiating these agreements not necessarily with countries with whom EU member states already trade a lot, but more where there is less trade and where we're trying to see if we can develop it. So hence countries in Asia, the Mercosur, Latin America, tends to be much more the focus. And I think the other part of the picture to keep in mind is really what trade agreements do. They focus on disciplining government actions. They focus on keeping tariffs below a certain level or eliminating tariffs, making sure there's not discrimination in the treatment of either goods or services or investors. And whilst they're intended to spur business opportunities, that's exactly, of course, that's the ultimate objective. In a way, that is not what they regulate. What they regulate is how the government acts in particular situations. So in that sense, the Judgment Convention, for example, is less directly linked to the types of things that we're trying to do in international trade agreements. I think there are lots of issues around trade policy just now, how much we will continue to negotiate FTAs, whether the focus is not going to go back onto trying to solve the significant problems there are in the WTO. But I think something that is of interest and that links in a bit is we're increasingly turning to look at implementation. So we've negotiated these agreements. We're now looking at how do we make them work, and that is taking us into the territory of trying to look at, well, what do businesses actually need to be able to take advantage of these opportunities. For the moment, that is focused really on how to put it, information provision. Creating online tools where, in particular, small and medium-sized companies can go online and can see, well, there are particular opportunities for my business in that specific country, and I'm going to follow these up. I think it'll be interesting to see over the next years, and particularly, as I hope, with the Judgment Convention being ratified and eventually entering into force. I think it'll be interesting to see how these efforts in implementation might gradually join into some of these efforts around making judgments enforceable, these other types of mechanisms. But we will always have to manage the policy direction that Andreas explained and the policy direction that we're working on, and see how best these things fit together.
Well, and that's really promising. And just to give a little bit more of background where this idea comes from, there are a couple of trade agreements, namely the TPP and the RCEP, that have these aspirational provisions. We can discuss to what extent those are really relevant or not, where there is language to encourage the parties to join certain international standards. It's true that this experience has been done only in relation to e-commerce standards from UNCITRAL, but it feels that encouragement to be included in trade agreements, these aspirational provisions, could be interesting, since it would be a bilateral negotiation where both parties would have a stake on, and they would not have to only rely on the Brussels effect, which is loved by some but hated by many. I hand it to Matthias.
Thank you, Joao. If I just may add to this point, as inspirational articles within these agreements, there is one example we were also a little bit talking about in the preparation, and that is Article 20 of the EU, Georgia and Moldova Association Agreement. And this article directly addresses our issue. The heading is legal cooperation, and it says, the parties agree to develop judicial cooperation in civil and commercial matters as regards the negotiation, ratification, and implementation of multilateral conventions on civil judicial cooperation, and in particular, the conventions of the Hague Conference on Private International Law in the field of international legal cooperation and litigation. This is exactly the inspirational article that I allow myself to propose here and now as a model for free trade agreements. Can it harm anything, Colin? I would not think so. It's just an inspiration, but it guides the parties towards the right direction to think at least about establishing legal cooperation. And it seems to me that this would be a good thing in each and every trade relation that is established by the EU. And I fully accept that the main focus of your activities or your DG is on regulating government's activities, reducing tariffs and non-tariff trade barriers and so on and so forth. But as you said, ultimately it is to serve the parties, the business parties, and to spark business opportunities. And if that is so, I would think that such a provision should be included in free trade agreements.
Yeah, let me just say maybe one or two things about that. I mean, I think first you have to keep in mind that these association agreements are different from free trade agreements. They have a much broader purpose and tend typically to take in a greater range of issues. This is, of course, an example of such an issue, but there are also many other issues that are typically taken up in association agreements. And the tendency that we have is to keep the trade agreements, I would say, fairly narrow. I think many would debate exactly how narrow, but we tend to keep them fairly narrow. And we tend to keep them on to areas which are fall under the union's competence for trade matters. So there's tends often to be a legal base issue, and I think that is why you do not typically see these types of provisions in trade agreements. But I think, as I said, I don't think I think it's very interesting to take part in this discussion. I think we will see as the trade policy evolves and begins to focus much more, as I said, on implementation and how individual companies and operators benefit. I think we will see how these types of things evolve. And I think a lot will also depend on how our colleagues in DG Just and Andreas's team also see this interaction over time. We do, and I think this is the interesting point about these provisions. We do prefer, and we do put a focus on multilateralism. And we do encourage the use of multilateral standards or approaches. So in that sense, I think this type of thing is encouraging. But whether we can go in that direction in the future is something that we will have to see.
One last observation from my side, and then we should really go into Q&As from the audience, or maybe two observations, if I may. Multilateralism. This is also something that I would like to add to Andreas's intervention. Yes, multilateralism is the right perspective, but it is fully implemented when we convince our trade partners to accede to multilateral conventions as they are offered, for example, by the HCCH, now in an entire package. That would be the perfect way towards multilateralism, I would think. And Colin, yes, I fully accept that trade agreements should be kept somehow in a narrow framework to make things work, to get to a yes in the negotiations. On the other hand, DG Trade communicates to us that trade is no longer just about trade. And if we look at modern trade agreements, we can see a lot of policy issues included in these trade agreements, but the one that is so close to the core objective of the free trade agreements, judicial cooperation, that is somehow a little bit still out of sight. I allow myself to say at this point, but we will not resolve this here and now. As you say, we will see how things will develop, and of course we are all hoping the best. Is that the time to open the floor, Joao, for questions from the audience?
Yes, and we have a question from Futura Cola, but it's very specific about the provision of the convention. And if she doesn't mind, the PB would write her directly to discuss with her that question. And maybe Tobias Lutfi has a question about the prospects of Russia joining the convention, if I get it correctly. He refers in particular to a recent blog post by Gilles Coniberti in which he discusses the prospect of Russia signing the convention, and he argues that for Russia there would not be much to be gained. His argument is that Russia is pretty conservative when it comes to recognizing foreign judgments, but because other countries are more liberal, Russian judgments currently have a wider reach outside of Russia than foreign judgments do in Russia. So what is it in it for countries like Russia? I could add a couple of other countries to this question. Someone in the panel would like to try and address this question. Andreas, on a very theoretical.
Hang on, Joao, my apologies. I was just distracted by something else. I'm
okay,
happy
sorry.
to reply, but if you can,
it's
sorry about
that. The question is basically Russia is rather conservative in recognizing foreign judgments, and so what is in it for countries like Russia to join the convention, since they are very conservative in importing judgments? I guess the question, the answer would be that they would benefit from exporting their judgments more easily. Any thoughts?
Well, I think if you may, or if I may, I think that's, I would consider that logic, as being a bit too restrictive, because I think that, if you look at it in a very narrow way and say a country, is very rigid about, basically not recognizing and enforcing foreign judgments, in a zero-sum game, they could say, we're just losing because we might have to recognize and enforce foreign judgments, whereas maybe our judgments, other countries are more liberal. But of course, a lot of countries currently have reciprocity systems, so that if Russia is rigid, they will also be rigid. But I think what this position misses, is the impact on trade. Because if I am, a European SME and I'm thinking about entering into a trade relationship with a Russian enterprise that doesn't have any assets to enforce into, in the EU. So I know that if I ever need to enforce anything against that company, I have to go to Russia. I might get a judgment from the EU because, where there is a legitimate head of jurisdiction in the EU, but I know that I ask my lawyer, will I ever be able to enforce that judgment in Russia? And, my lawyer tells me, well, that's almost impossible. I will think twice before I consider such a trade relationship. So I think it's very much that relationship between judicial cooperation and trade that should make it also a worthwhile exercise for Russia to consider this. And as you have mentioned yourself, apparently Russia is actively considering joining the convention. So, when they make the policy judgment on whether there's something in it for them, if they're, have developed a reasonably positive stance on that, then they will have come to the conclusion that probably for these, economic reasons, there is something in it for them.
Thank you very much. There is another question from my colleague Moritz Brinkmann.
And yes, Christoph, sorry to interrupt, because Christoph raised his hand.
Yes, no, sorry, and I have been listening to all these discussions with great interest indeed. With respect to Russia, and without revealing any secrets whatsoever, first of all, I can confirm that the interest is very tangible indeed. And I base that also on direct communications with the Ministry of Justice, very recent communication with the Ministry of Justice in Moscow. The procedure now is that they are seeking presidential approval for the signing, which could indeed take place in the first half of next year. So a very tangible sign. And in that broader context, we should not forget that the convention only establishes a floor. It's a minimum standard convention. And if as a state you are not able to join that minimum standard, allowing for just, let's say, basic circulation of judicial decisions, well, as Andrea said, you may eventually really be cut off basic international trade and commerce streams and relationships, which brings me to the the real takeaway on the interesting discussion we had between judicial cooperation and the trade agreements. Of course, it would be helpful, I think, to have such incentives in trade agreements and invitations expressed to states to join the basic conventions, choice of court judgments, and indeed others. But at the end of the day, for cross-border trade and commerce and foreign direct investment to be effective, to be predictable, to be secure, you need to know framework. And if the framework is not in place, you just won't do business beyond a certain degree. And in terms of the kind of strategic promotion and inclusion of these developments and encouragements to become a party to a convention, whether or not it's mentioned in a trade agreement, I always remind all our members that they approved our strategic plan. And under the strategic plan, all of our members are indeed strongly invited to promote our instruments vis-a-vis other states and indeed RAIOs as well. So the encouragement to sign and to become party to the conventions does not necessarily have to be part of a formal instrument. It can and should indeed also come directly from our members. Thank you.
Thank you, Christoph, for this amendment. May we now turn to the next question by Moritz Brinkmann, directed to Andreas Stein and Colin Brown. And this is the Brexit question. Yeah, we are going towards a no-deal Brexit and also a no-deal at the moment in terms of judicial cooperation, as it seems. So the question is, if I summarize it correctly, what are the options? Is it the Lugano Convention? Is it the Hague Convention? Is it the two of them? What is the view from Europe, so to speak, towards this question?
Thank you, Matthias. Maybe you allow me to take this one as well. I don't want to monopolize, but I think Colin is not directly involved in these direct judicial cooperation issues. We're not currently negotiating a free trade agreement. Well, we are, but that's a that he can talk about, but not the judicial cooperation element specifically. Well, this is, you will understand that this is a politically sensitive question, because everything around Brexit is sensitive. I think the underlying assumption in the question, as you've put it, that we're heading for a no deal, I think that's not decided yet. I think we're in a crucial final negotiation stage, and in that negotiation stage, we're really focusing on getting a deal, basically, because the EU wants a deal with the UK, and we're not dealing with issues, that loom beyond the decision on whether or not there will be a deal. What I can tell you is that judicial cooperation in civil matters is not a subject in the negotiations about the future relationship with the UK. That was jointly agreed. So whatever is hammered out at the moment, the judicial cooperation is not an issue that is under discussion. And I think hopefully it's understandable that, from the EU's perspective, whatever follows after what we know about the final fate of a deal with the UK, it's very difficult to project what will or will not happen, because it depends a bit also on the overall political situation. What I can tell you is that in general, what we have envisaged is that the Hague Conventions in the fields where they exist, are the appropriate solution for the relations also with the UK, so that if the EU ratifies the Judgments Convention and the UK ratifies the Judgments Convention, we welcome the ratification by any third country of the Judgments Convention. And speaking jokingly, I think the UK would certainly not be a candidate for an Article 29 objection. This is a daring statement, but I think I can make it anyway. So that's definitely a possibility. Whether there are other possibilities, I think I really have to ask for your understanding that I cannot elaborate on that at this stage, because this is definitely above my pay grade.
So we don't get any information about the Lugano Convention and its prospects in that respect. Is that what you're saying?
Well, I think it's a publicly known thing that the UK has expressed an interest. So this is a pending matter, but we're considering this. But I think the way we will continue to consider this also depends on what happens in the overall negotiations about the future relationship with the UK. So that's something I cannot currently pronounce on.
Thank you very much.
We have one more question for you, Andreas, and if I'm not mistaken, it's from Tel Aviv. Assuming the EU ratifies the convention, what would be the fate of the existing bilateral recognition and enforcement agreements of member states with third parties? Is it likely that the EU will have any guidance to members on how these could operate?
Well, I think that probably this is a question that deals with the relationship between the convention and other international agreements, be they bilateral or multilateral. So I think, as Christoph has said, the convention is a floor. It doesn't stand in the way of more generous national provisions. It also doesn't stand in the way of more generous bilateral agreements. So I think this is not. I think this is not a question on which the EU would have to take a decision, because that's a question that's already governed in the convention itself, in the provision on the relationship with other international agreements.
There is another question of a juridical character by Nihal Sousa from the University of Bonn, and maybe it's best placed with our experts from the HCCH. Maybe Christoph or Joao would like to comment on it regarding the scope of public policy exceptions as grounds for refusing enforcement under the Judgments Convention would the exception be construed as narrowly as in commercial arbitration, i.e. the New York Convention?
Well, I'm a moderator, but I would, if Nihal doesn't mind, I would reach out to her and share the exact wording that was thoroughly discussed in the explanatory report. Of course, it needs to be interpreted autonomously and later on uniformly. And there is no reason to believe that the interpretation would deviate strongly from what is the standard of the interpretation of public policy under the New York Convention at the international level. I'm not saying that it will be the same, but it's hard to see a reason for it to deviate considerably. But I will reach out to Nihal and share with her the related paragraphs of the explanatory report that, of course, was only published today, and we can discuss further then.
Thank you. Next question. Question for Christoph from Liz Harvey from the University of Saarland. You propose the package of conventions should be used together. Is it possible to name some potential downfalls of using, for example, just the HCCH Convention on Recognition and Enforcement, as opposed to using it in conjunction with the HCCH Convention on Judgments? Maybe that should read choice of court agreements, but I think the question is clear enough. Thank you.
Thank you. I hope it is clear enough. But in relation to judgments and choice of court, yes, they are very much complementary. Of course, the Judgments Convention follows as closely as possible the wording of the Choice of Court Convention. But when you look at the Judgments Convention, it explicitly only refers to non-exclusive choice of court agreements. So ideally, to fully cover the broad scope of exclusive choice of court agreements under choice of court and other agreements and much more under judgments, you really should join both and get the full advantages across the picture. But I also still believe that if you want to facilitate and accelerate purely procedural aspects in cross-border litigation, if not the case already, states should also join, in particular and at minimum, service and evidence. Because if you have to wait for 2 years before your request for service abroad reaches the addressee, what's the point of having a nice potential judgments convention in place when actually you cannot proceed with the procedure because basic procedural steps have not been completed on time. So if you want to make full advantage of what we basically regard as global standards, including in cross-border civil procedural aspects, then a state should really join the package.
Thank you very much. We are looking into the chat, and there is one last question, maybe to our EU experts. Any plans on how the EU plans to deal with third states who are not members of the HCCH, but are on some kind of path towards the EU? The question is about Kosovo.
Yes.
Andreas, maybe you would be willing to answer to that. Thank you.
Sure. I can answer to that. I think the first element of the reply is that, but that's just a clarification, that membership of the organization is not necessarily a requirement in order to become a party to the convention. So that any policy of encouraging states to become parties to the Judgments Convention is not necessarily dependent on them being members of the organization. And I think actually that gives me, irrespective of any specific country, that gives me an opportunity to also come back to something very briefly that was discussed earlier, namely, what's the appropriate policy in order to promote ratification of the Judgments Convention. And you, Matthias, brought into play and very strongly advocated that an inspirational clause in trade agreements could be a way of doing that. I think there are other ways as well, and maybe I can use this opportunity to exemplify how we do promote the convention, because obviously, whether there is an EU, accession prospect at some stage, or a candidate country status, or whether it's just neighborhood policy towards neighboring countries, the EU takes a number of actions in order to bring about developments that would also be beneficial in terms of promoting the ratification of the Hague Conventions. So, I mean, if you're looking, for example, at issues like helping to install a judiciary that complies with rule of law standards, the EU provides important assistance in that respect. Let me just name, the Ukraine, which is not such a hypothetical example, because Ukraine is also a country that has expressed strong interest in the Judgments Convention, where in our cooperation and the assistance we provide, rule of law plays a large role, and this can easily go together with other means of financial capacity building in order to be able to do what's required under the conventions to both promote the Hague Conventions and also help countries to get sort of in shape in order to become partners under those conventions, and prepare their accessions. We do this in a number. I can also, Euromed. There is a financial program where we support North African countries in capacity building, and that's also an area that's still underrepresented in accession to Hague Conventions, on all fronts, not only the Judgments Convention, obviously, which is new, but also the family law conventions. So I think we're definitely willing and determined to use the tools that we have at hand in order to promote the Hague Conventions, and also to help countries approach the process and the readiness to join those conventions.
If that is the case, our mission of today is fully accomplished, and we are extremely grateful for explaining to us in more detail what your DG, what the EU, what the Commission is doing in that respect. We are having a much better understanding now, and we have gathered a lot of perspectives towards trade relations, trade agreements, to neighboring countries' relations, and so on and so forth. To me, it was a really fascinating panel. Thank you so much for being part of it, for intervening, for raising questions, and of course, my greatest thanks to our distinguished panelists. Last word from my side before I hand over to Joao for the very last words. Special thanks to my colleagues from the University of Bonn, who I see here in the video room, Nina Detloff, Moritz Brinkmann, and Philip Royce. They are all working together in this conference project, and I am very grateful for that. Hopefully, I will see, and we will see all of you next year, September 2021, 13th and 14th September, on site, on campus, hopefully in better conditions and surroundings without any COVID-19. It's a big wish, of course. We will see, and we will hope the best, as well as in relation to the HCCH 2019 Judgments Convention. Thank you very much. Good evening from my side.
Thank you, Matthias, and we are on the clock. And so just to sum up, I think the roundtable actually answered the question and addressed what are the prospects for judicial cooperation in civil or commercial matters between the EU and third countries, and we could not ask for more. So thank you very much to all, and I'll see you in the next webinar or next year in Bonn. Thank you.